Key decisions today on what evidence will be allowed in the murder trial of Drew Peterson. His trial begins with jury selection next month. NBC5's Kim Vadas has more from the Will County Courthouse.
While he flashed a smirk, a much more subdued Drew Peterson emerged in the courtroom as his attorneys battled to block questionable evidence from showing up at the trial next month in the murder of his third wife, Kathleen Savio. The biggest battles are over hearsay evidence, namely from Savio's divorce lawyer, Harry Smith, who also had conversations with Peterson's fourth wife, Stacy, who's vanished. The defense wants him banned, saying Smith's statements violate attorney-client privilege.
No, you can't have lawyers going out there telling people what their clients allegedly told them. That's privilege.
Also being debated, comments Stacy made to her pastor that Drew Peterson coached her to lie when investigators asked her about Savio.
Reverend Shorey is a hack who is in this just for his own benefit and his own publicity, and you shouldn't believe anything he says, and the jury shouldn't hear what he says.
In all, 9 motions are being debated. The defense winning efforts to get a daily witness list to streamline the trial, but a request for an entirely new jury pool that was already paired to 175 over 2 years ago was denied.
A lot of things have happened since that, and we want a fresh start.
Got to ask what they think of Rob Lowe.
But the judge will allow evidence Peterson had a lockpick. It was never determined how Kathleen Savio's killer got into her house. She was found dead in a dry bathtub. First, it was ruled an accident, then a homicide after Stacy disappeared.
We don't want them to be able to say to the jury, well, maybe someone came in through the window, maybe someone came in through the door, maybe someone came in through the garage, maybe someone slithered down the chimney. You figure out how they got in. That's not right.
Former Cook County State's Attorney Thomas Glasgow joins us with more, and we are just learning. I want to update you a little bit. The judge did make a ruling about whether or not the divorce lawyer for Kathleen Savio will be allowed to testify about what she said to him. That is not a complete ruling. I understand we're not clear exactly on what the final determination is on that, so we'll bring you that, but he did make some sort of ruling. It does sound like he's leaning toward allowing this testimony anyway, at least so far. How significant is this potential ruling and the motion itself, getting all this hearsay evidence in?
Well, this entire case has been built around hearsay evidence. We've talked about the hearsay evidence that went up to the appellate court, Supreme Court back down, and the statements that have been made by outside witnesses, there is no direct evidence towards Drew Peterson's guilt. So therefore, we're relying on hearsay evidence from other people as to what he said or other people said. This is another piece of hearsay evidence by the attorney from Kathleen Savio to her attorney saying, if I die, please make sure you go to the authorities and tell them what occurred. That is an exception under the rules of professional ethics. If a client gives consent to allow confidential information out, that is something that is an exception and can be allowed. Normally, what you say to me in confidence, I can never tell anyone, and a court can't even order me to do so unless it has proper and just cause. However, if the client consents, that's something that can be allowed, and in this case, that's what the judge is going to be allowing.
All right. Now, also, Drew Peterson, because he was tired of sitting in the Will County jail, apparently, said, look, all that hearsay evidence that went up to the appellate court, the Supreme Court, and back down, he said, forget it. I don't even want to deal with it. Was that wise? I mean, because if this case, if the crux of the case does have to deal with this hearsay evidence, shouldn't he be hoping and praying and fighting all the way to the Supreme Court as much as he can? Right. That's something that,
you have to look at. Do I want to wait for another 2 to 3 years for this to be appealed and be kept in the incarceration, or do I want to get to trial? Because the court has ruled that he's going to stay in custody while these appeals go back and forth. There's only hearsay evidence against me. Let's go to trial. There's no direct evidence. Let's get the show on the road and get this out there. That's the way a lot of defendants will look at this when they get down to the rubber meets the road.
You're a defense attorney, too.
Absolutely.
Would you say, okay, let's do it? What would you recommend?
Well, if you're going to battle for another 2 years, it's the client's choice as to whether or not they want to appeal. If they believe that this is something that they want to go forward with, they do have a case that has no direct evidence. And the entire case they're going to be pointing at, do you believe that there's a body? If you look at the doors, do you think she's going to walk in? Those sort of types of arguments that we've all seen on the TV crime dramas. In this particular situation, we don't have a body. There's no corpus delicti. There's nobody that is, in the case with Savio, it was first ruled an accident as opposed to a homicide. So you've got reasonable doubt built in. Do you really want to dance around this and go back up on the appeals when you have a very strong case to defend?
Okay. What about the jury pool? They said they're going to keep that same jury pool from 2 years ago. What effect does that have?
Well, they were ordered not to listen to any commentary on the news.
Since there's been a Lifetime movie out with Rob Lowe.
Correct.
And I mean, it's like, how do you fight it?
They're going to take the jury at their word that we haven't listened to anything or seen anything. But you all know that, in the days of mass media and the internet, we're going to be able to hear or see something about it. The question really arises, where is he going to get a fair jury on this planet? Everybody knows who the man is. I think more people know who he is than the Vice President of the United States.
You could be right about that, which is sad, by the way. And real quickly, Kim made this point about this how did anybody get in? Did he have a lockpick? What's that all about? That whole, the idea of, which is kind of confusing to me.
It's a legal concept of shifting the burden towards the defendant. The prosecution always has the burden, and they have to prove beyond a reasonable doubt how they committed a crime. You can't force the defendant, or in this case, the jury, to guess how something occurred. And they don't have any evidence of how he got in. They don't know if he came through the window, or if he knocked on the door, or if, in this case, as is alleged, that he picked the lock. So in that case, you're making the jury make a leap of faith to say, that's how he must have gotten in. Now, a jury can make certain assumptions, but and it is an element of the offense? No, it's really not. But it's a piece of evidence that the defense wants the prosecution to prove.
Gotcha. Okay. More to come with Drew Peterson, we know, and I know we'll be talking to you some more about it.
Thank you very much.
Thanks, Tom.
It's good to see you.
You too. Still ahead, the Chicago skyline to hand.